The government, through three members of the Cabinet Subcommittee on ICC Matters, Mutula Kilonzo, Professor George Saitoti, and Amos Swako, announced that it would challenge the admissibility of the post-election violence cases that the 6 Kenyans have been summoned to answer to at the Hague-based court. However, that application may come a cropper. The legal division of the ICC pretrial chamber points out that the government must first prove that there were active investigations or prosecutions against the 6 suspects.
The challenge has to be based on actual national proceedings. Actual national proceedings, prosecutions, against the same persons and for the same crimes.
The government, through the Attorney General, was hoping to use the expected reforms in the judiciary, top among them the vetting of all judges and magistrates, police reforms and the revamping of the prosecutorial arm, to prove that it was able and willing to deal with the post-election violence matter as a basis for challenging the admissibility of the cases.
By August, we will be able to hire prosecutors better than Mr. Okambo. We will be able to produce judges far better than, I shouldn't use the expression, but far better than others.
But the ICC pretrial chamber's legal division has warned that the government may not have any headway with its application.
You cannot challenge admissibility of cases on the basis of future proceedings before eventually a future court or a court to be established.
Lands Minister James Orengo, who is also a member of the Cabinet Subcommittee on ICC, said though the government had the right to make the admissibility challenge through Articles 17, 18 and 19 of the Rome Statute, it had acted too late. He said the matter took a different turn when it became impossible to establish a local judicial mechanism to deal with the post-election violence cases.
Okay, so if the Attorney General now went to The Hague to say that this case is not admissible, and then he's asked, where is the evidence that you have investigated or you're investigating, he will find it very difficult, to answer those questions.
For now, the Ocampo 6 will have to prepare for their day to the Hague-based court early next month, where the post-election violence charges they are facing will be read out to them formally. The last time a local tribunal bill was brought in Parliament, a majority of members of Parliament were unanimous that let's not be vague, let's go to the Hague. So the Attorney General will have his work clearly cut out for him when he makes that application on admissibility and jurisdiction before the ICC on the Kenyan post-election violence cases. Francis Gashuri, Citizen Live at 9.